An assault is carried out by a threat of bodily harm coupled with an apparent present ability to cause the harm. It is both a crime and a tort, and therefore may result in either criminal and/or civil liability. Generally, the common law definition is the same in criminal and tort law. The following video is an example of assault.
I think it's really good.
Really?
Yeah.
Yeah. Let's go 2K15 right now.
Let's go, buddy.
I'll kill you in it.
PS4.
Yeah, I'll kill you in it.
I'll rock you.
Hey man, where do you think you're going? Home. No, don't go home. Why? I'll punch you out. Get out of here. Yeah, get out of here. I'm calling Fuck you up right now.
In the case of Wilson versus Bobby, the following is an application by the defendant to open up a judgment given in default of appearance. The underlying issue is whether provocation can constitute contributory negligence in a tort action for assault, or whether provocations otherwise reduce damages. A few of the facts from the case. On November 5th, 1995, the defendant assaulted the plaintiff in the parking lot of a bar. The plaintiff suffered serious injuries and was in a coma for approximately 26 days. On December 5th, 1996, the defendant was convicted of aggravated assault and was sentenced to 3 years in prison. On November 22nd, 1996, the plaintiff commenced an action for damages for his injuries. While the tort sued on is said to be assault, it is in fact a battery. The confusion arising because what is an assault in criminal law is in tort a battery. The defendant filed a statement of defense on April 14, 1997, denying the assault, or in the alternative, pleading self-defense or a consensual fight. Examinations for discovery were held in November of 1998. In July of 1999, the defendant's counsel ceased to act, giving the address for service of the defendants as Box 565, Bonaccord. Counsel for the plaintiff brought a motion for summary judgment, eventually returnable on June 4, 2002. The notice of motion was sent to the defendant at his designated address for service at Box 565, Bonaccord, both by ordinary mail and by certified mail. The defendant acknowledges receiving a postcard from the post office indicating that there was a certified mail to be picked up, admits that he did not make arrangements to pick up the letter because of his work schedule, but denies knowing the contents of the letter. The defendant alleges that he never received the copies of the documents sent by ordinary mail, although he acknowledges that his mailing address at the time was Box 565, Bonaccord. The plaintiff deposes that the documents sent by ordinary mail were never returned and were presumed to be received. On June 4, 2002, summary judgment was granted against the defendant, in default of his appearance on the return date of the summary judgment application. A trial to determine the quantum of the plaintiff's damages was directed. The damage assessment is presently scheduled for January 23, 2006. In August of 2005, the plaintiffs attempted to serve the defendant with notice of trial, the certificate of readiness, and certain medical reports that will be relied on at the assessment of damages. This material eventually came to the attention of the defendant, who brought an application to open up the default judgment. The defendant acknowledges that the assault happened and that he bears some responsibility for damages, but he argues that the plaintiff should be held contributorily negligent because the plaintiff provoked the assault. The defendant deposes that on the night of the assault, he was trying to gain access to his own car in the parking lot, when the plaintiff attacked him without no reason or provocation. The defendant deposes to his belief that the attack was made on the instructions of Barbara Gilman, a previous girlfriend of the defendant who had grievance against him. The defendant deposes that his assault on the plaintiff was provoked by the initial assault by the plaintiff, although he acknowledges that his response to the attack exceeded all reasonable limits. While the defendant acknowledges that he was held criminally responsible for the assault, He maintains a position that he should be entitled to defend the tort action based on the provocation of the plaintiff. The plaintiff has no memory of the assault due to the brain injury he suffered, and so cannot rebut these allegations. At the criminal trial, Miss Gilman apparently denied any involvement.